The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. Good afternoon. We have 3 cases that will be submitted. They are as follows. Northeast Community School District versus Easton Valley Community School District. Second case is State of Iowa versus Damian Seats. And the last case is Roberts Dairy and Crawford and Company versus Grady Billick, and Grady Billick versus Roberts Dairy and Old Republic Insurance Company. The last consolidated case will be submitted to the court without argument and is therefore submitted, and we'll now hear the arguments in the first case, Northeast Community School District. Mr. Bracken.
May it please the court. My name is Drew Bracken. I'm with the Allers & Cooney Law Firm here in Des Moines. We represent the Northeast Community School District. That district is located in Goose Lake, Clinton County, Iowa. In 2010, the Northeast Community School District entered into a whole grade sharing agreement with its neighbor, the East Central Community School District. East Central is located, or was located, in Miles and Sebula. Under a whole grade sharing agreement, the parties agreed that all of East Central's 7 through 12 students would be transported by East Central down to Goose Lake, where they would attend school with all the Northeast high school and middle school students there. The agreement began in 2010, and it was up and running in the 11-12 and 12-13 school year. At about the same time, a popular movement was created to merge the school districts in Preston and East Central. Both of those in Jackson County. As that matter worked its way through the system, the whole grade sharing agreement was up and running. Eventually, the reorganization, which proposed a merger of those 2 districts, was submitted to the voters in East Central and Preston, those 2 districts. It was approved by the voters in both districts, and therefore the new district, called the Easton Valley Community School District, was formed effective on July 1st of 2013. The board of directors, a new board of directors was elected to govern the new Easton Valley Community School District. That board took control of all the assets and liabilities of the 2 predecessor school districts, but then took the extraordinary measure to disavow or repudiate the whole grade sharing agreement with Northeast. Northeast responded by filing a declaratory judgment action in Clinton County, asking the court to decide whether the whole grade sharing agreement, the contract between Northeast and East Central, was a valid and binding contract on East Central and its successor, the Easton Valley Community School District. By the time the court got to that matter, the time for performance had passed, and so the Northeast amended its petition to also add now a breach of contract claim. The parties submitted cross motions for summary judgment. The district court granted Easton Valley's motion and denied Northeast's motion for summary judgment, essentially holding that the whole grade sharing agreement, the contract between Northeast and East Central, was not binding on East Central's successor, Easton Valley. Am I doing all right on the names? The names are a little, thank you, I appreciate that. The general rule here is what Northeast is here to ask the court to enforce. The general rule is true in corporate mergers, whether they be public or private sector type mergers. We've cited to the court the sources for that general rule, the rule being that in a pure merger situation, the successor corporation inherits the liabilities and assets of the predecessors.
Mr. Bracken, and I agree, the notion that, as a matter of contract law, you can just kind of get out of a contract by merging with another entity, that seems kind of foreign to me. But as I look at 275.33, and there's, I know, several provisions of code involved in this case, there's some provisions about what happens to certain contracts, such as collective bargaining, teacher contracts, things like that. Could one infer from the fact that the legislature made special provision for these kinds of contracts that other contracts go away?
No, sir. First of all, we know that the Attorney General has taken the position for literally decades that all contracts survive the merger process. I think the reason that the legislature was wise enough to include that provision is because those contracts are naturally going to collide with each other. If you've got a collective bargaining agreement at District A and a collective bargaining agreement at District B, the successor corporation will inherit both and then do what? So the legislature, I think, in anticipation of those conflicts of contracts, expressed its preferences for how those contracts would be prioritized, so to speak. So I think that's the purpose of that particular subsection in 275. Yes, sir. Now, if you go back to section 275-29, it talks about the idea that the districts that are forming this new corporation should get together and reconcile where those conflicts may exist otherwise, but the legislature has given us that specific direction in those cases.
Taking your argument to the logical conclusion, Easton Valley would be a party to this whole sharing agreement, wouldn't they? Because they inherit the rights and liability of it.
Yes, sir.
Then why wouldn't the arbitration clause come into effect to bind, I gotta get these names right.
Right.
Easton Valley
Right.
and Northeastern, and that's paragraph 12. Because it says if there's a conflict
Right.
and they can't agree on anything, you go to arbitration. So where's the jurisdiction of the court? If
The jurisdiction of the court is, remember that we originally filed this as a declaratory judgment action. We're simply asking for the court to decide whether the contract was enforceable or not. You look under the rules of civil procedure for declaratory judgment actions, it's a perfectly appropriate mechanism to determine the rights and liabilities
So
of
if we were
parties.
to determine, because they talk about arbitration and
Yes.
they're talking about all this stuff in your briefs.
Yes.
If we were to determine that it was a binding contract, those are issues we wouldn't have to reach.
Right,
And either party would probably have to take it to arbitration if we agree with you.
right.
Okay.
Right. The fundamental notion is that, the Easton Valley Board came right out and repudiated the agreement, says we're not bound by that agreement. And so that left Northeast with no remedy whatsoever. They couldn't ask for arbitration for an agreement that Easton Valley was disavowing, so we went to the district court.
But you're asking for damages, that's my problem. I mean, you're asking for damages and other relief, which I don't know if that's acceptable now, if you're right, and I don't know if you're right yet.
We've asked for lots of
figured
different
that
things. The original petition was for a declaratory judgment and
Tell me what you really want.
What we really, really
What
want?
you really want, yeah.
Yes.
I mean, you asked for a whole lot of stuff, but what do you
Right.
really want?
Well, whatever remedies are available from the court, but obviously the first petition asked for a declaratory judgment that said that the contract was binding on the successor school district and mandamus, compelling them to comply with the agreement. Now, if that means arbitration, that's fine. If that's the remedy that is most appropriate under the circumstances, that's fine.
Can you get mandamus with an arbitration clause?
I think you at least get compelling performance, at least as far as the arbitration goes, certainly. And now, we haven't even gotten to that part about what other remedies might be available, because we didn't get out of the chute with the simple premise of, is the contract even enforceable against Easton Valley?
If the district court is correct that the contract is void on public policy, which is different than just being void, are you still entitled to damages?
Well, first of all, I have to say, I don't think it's void on public policy grounds, so I sort of reject the premise.
Whatever the grounds the district court used, they talked about you can negotiate your duties, which is, I look at it as public policy. We call it whatever we want. But if the district court was right, you're still entitled to damages.
Well, the folks in Northeast certainly believe so. That there was certainly reliance on the fact that they would be providing continued programming. There was reliance on the fact that some of the costs that go with that sharing agreement were still borne by Northeast. The poor students up at East Central, who were supposed to be provided with transportation services to Goose Lake, weren't provided those anymore. The teachers at Northeast, who were supposed to be provided with compensation for educating these other students, weren't provided with that compensation. And there was a facilities agreement that went along with it that talked about compensation for under the statewide sales tax.
One of your arguments is that you're an effective party, but didn't the legislature change that?
No. That is not one of our arguments. We are not claiming that we are a school district affected by the reorganization, because the legislature, that's a term of art now under Chapter 275, which would say that only the parties to the reorganization are parties affected by the reorganization. So in our case,
you would agree that Ruthven's no good law anymore?
no, it's because of the change in the law, right? Doesn't apply anymore. The only thing that is interesting about Ruthven is the idea that the successor corporations do have to resolve. Under Ruthven, they do have to resolve their assets and liabilities. This, what's interesting here is that what Easton Valley is trying to do is use reorganization to discharge itself of its debts.
I have one last question. I'm going to shut up. But tell me about how this is different from the Marco case.
The Marco case, the street case in Cedar Falls, if I have it
Street
right?
case, how do you distinguish this? Because, it was a contract with a public entity with a contract with another entity.
Right.
And the court said there were no successors in interest in that case.
Right. The biggest difference is that it's the old rule. It's really a form of Dillon's rule that we're talking about here. There's an old rule that says that one legislature cannot bind the next legislature. It's the old idea too, like Dillon's rule, that you can only do what the legislature specifically authorizes to do, or implicitly or by necessity. Well, the difference, of course, between this case and all the other ones cited by Easton Valley is we've got specific statutory authority to bless whole grade sharing agreements in the state of Iowa. Iowa Code Section 282.10 created the whole process of whole grade sharing. In fact, if I step back a little farther, the Iowa Code Chapter 28E in 1965 blessed sharing of governmental operations. I think in a large measure, 28E overrules that old rule of jurisprudence about the idea of legislatures binding themselves into the future or binding other legislatures, because 28E authorizes the joint operation of governmental functions. So the Marco agreement between a city and a developer simply wasn't authorized by any other statutory source.
If we affirm the district court, would we be undermining 2080?
Absolutely. I think that's the real threatening nature of the decision in this case. The idea is that if one legislature can't bind another, in this case a school board, it could be a city council, it could be a board of supervisors, can't bind itself into the future, not only are you undermining Chapter 28E, you're undermining all the things that cities and school districts and counties have to do, such as big infrastructure projects, borrowing money. They're encumbering themselves for literally decades in some of these cases. And if we can't do that, you're turning your back on all these efforts to try and let local governments cooperate with each other and do the public's business over the long term. So the curious thing in this case is, well, when it occurs to a district court judge that perhaps this doesn't quite square under a public policy theory or what have you, what the district court judge I think first has to do is respect the code in terms of 282.10, whether it's a whole grade sharing agreement there, whether it's a 2080 agreement here, whether it's other forms of sharing agreement that are authorized under Chapter 256 of the code between school districts and whatnot. The harm, I think, that the district court was concerned about, I think, was a very, very temporary harm. I think the district court perhaps was reading tea leaves a bit and said, well, if the people voted for consolidation, they must be voting against whole grade sharing, which I don't think is a necessary or a legitimate assumption to make. But the district court should have recognized that by inheriting this whole grade sharing agreement, the contract, Easton Valley also inherited the remedies available to it under the contract. Easton Valley could have negotiated a new contract, could have given notice that we're going to leave the contract at the end of its term, could have taken Northeast to arbitration or whatnot. So all those remedies were available. In one sense, too, is a fairly short term. If there's a conflict at all in those 2 points, it's a relatively short-term conflict that the Easton Valley Board actually had the power to remedy itself without repudiating the contract. For the reasons that we mentioned here and in the briefs, that Northeast Community School District would respectfully request that this court reverse the judgment of the district court and remand the case back to the district court for further proceedings.
One question.
Yes.
You indicated that reorganization shouldn't be a tool to discharge debts. The other side of the coin is perhaps creating debts shouldn't be a burden on the right to merge. And it seems to me the struggle here in part is between a contractual model and a democracy model. And the democracy model, one might suggest, is, well, you had the voters make this judgment, and there's a statutory framework to make the judgment. And it's one of consolidating. And that what's going on here is an effort to negotiate a set of contracts that thwarts consolidation, or at least burdens consolidation. I think you see the drift, and I'd like you just to address it
Yeah.
generally.
Well, first of all, I'd have to first give you the constitutional response, and that is a voter-approved referendum that does thwart a contract has constitutional problems. The contract
But if
has
you
to be
said
respected.
violated public, I mean, if there's a public policy to encourage
Yeah.
mergers pursuant to the
And
statutes.
and I'd still suggest that there's a constitutional issue when it comes to, extinguishing an existing contract, even if you do it for public policy reasons or if the popular vote wants to go that way. But secondly, I think there's a factual issue here that you might generate. And remember, procedurally, we're in a posture where the district court, granted their motion for summary judgment and has to take the facts from our side as true. If I may, just to finish up the answer to your question, I'm about to run out of time. But the East Central Board, who's being attacked here as on the premise of the question, was fully in charge in operations of the East Central Community School District. It was doing what it thought was best for the students of East Central at the time. And at the time it made its decisions, it entered its contracts, there was no Easton Valley Community School District. They had no way of knowing if there ever would be an Easton Valley Community School District. So I know that there's a theory on the other side that this was somehow a poison pill. And there's no evidence to support that kind of poison pill type argument, especially on the procedural posture that we're in right now. You can't accept that as true.
Well, I guess following up on Justice Appel's question, you say you couldn't take that as true, but when the whole grade sharing agreement was renewed, they stuck in the clause binding successors.
Right.
That has an appearance to me, at least superficially, that it was an effort of those opposing the merger to make it more costly or impede it somehow. Tell me why that is a completely ridiculous proposition.
I'll tell you, one response would be that may be what was necessary to make sure that Northeast stayed with East Central. If Northeast and East Central Board could see this potential problem on the horizon, remember these are tremendous logistical issues. You're going to move 100 and some students. You're literally going to close down a middle and a high school and move 100 and some students in this particular case from one community to the next. And these are things that you can't turn these systems on and off overnight or even in a year sometimes. That takes a lot of, so these kinds of agreements have to have some shelf life in order to make sure the parties can plan appropriately and still deliver good quality educational programs for students. Ultimately that's what these things are all about. So the notion that this was done only as a poison pill would be, I think that you're not giving much credit to the parties to the agreement. And I might add in the record, at least on our motion for summary judgment, we did add that it was actually a consultant from the Department of Ed that suggested that amendment to the agreement. It didn't come from the parties themselves. Thank you very much.
Thank you as well, Counsel. Mr. Gruhn.
Thank you. My name is Brian Gruhn, and I represent the Easton School District here today. May it please the court. East Central is not saying that Northeast couldn't bind themselves or couldn't bind East Central to some kind of a sharing agreement in the future. That's been suggested in the briefs that we argued that, but we didn't. What the real issue here is, could they bind a third-party board of directors, which is Easton, the third-party board of directors that was never part of the deal, never consulted, never signed on anything.
Let me
Yes.
ask this question then. Say there's a 2080 agreement between Scott County and Clinton County to take care of certain roads in Clinton County. And Clinton County has to pay for it. Clinton County has a election like we saw last night where everybody gets turned out, sort of like Obamacare, but this is the county road care, and they turn all the board of supervisors out and you get a brand new board of supervisors. Can they disavow the 2080 agreement?
It depends, probably not, because if there's statutory authority, then that's, you might say, like an exception to the legislative authority. So the body can't give away something that is their legislative authority, But if there's statutory authority on the side, like a 28E, yes, they could.
But isn't there statutory authority to enter in a whole grade sharing agreement, which is nothing more than a specialized
Yes, there is.
28E agreement?
But on both those things, the 28E agreement, by the way, if you ever look at the language in the 28E, it says, any power or privilege or authority exercised or capable of exercise. That word's capable is in there. In the instant case, for instance, we would argue that that Northeast is not capable of binding Easton.
Okay, then let me give you another hypothetical. All right. East Central has, they want to get a scoreboard for the football stadium. So they go to Coca-Cola. This kind of thing happens. I mean, you represent schools, right?
Right.
And Coca-Cola says, we'll build a scoreboard if you agree that Coca-Cola can sell exclusively at the school, just put in Coke machines, no Pepsi for the next 5 years.
Right.
And they sign the agreement. All right. And then there's this merger. Are you saying Easton's not bound? They can walk away?
No, I would say that something like the Coke deal would be a proprietary function. And if it's a proprietary function or quasi-private function, then that's legitimate and that
How
contract
is a
can be binding.
proprietary function different from a 2080 agreement that has specific legislative authorization? They're both authorized agreements.
But while a proprietary function is one that would be, like I think it was in the Dodds case, a contract for toilet paper and cotton and different things, those are all to serve the public purpose, but not in the governmental way or legislative way. It's in more like a quasi-private way, the way a private transaction would occur. And therefore, it wouldn't be considered a non-binding contract when the new government agency took control or took effect. It would still be binding.
So Counsel, I guess you're suggesting that the kind of issues that are ministerial, like what kind of pop we're going to sell at the ballpark, is so qualitatively different under 28E. A school merger is a governmental policy kind of issue that is different. Is that what you're saying?
Exactly.
Yeah.
But the duly constituted board of East Central and Northeast made these policy decisions. And if they can't bind a successor in interest, then I think you're arguing they can't bind a brand new school board, and that doesn't make sense to me.
Well, the reason they can't bind a brand new school board is the legislative function that school board has, and legislative functions would be things like deciding who's going to teach their children, when they're going to teach them, where they're going to teach them, what they're going to teach them, what the curriculum is.
Can they bind a brand new school board? Say everybody gets voted out and a new school board comes in. Can they bind a new school board?
I would say they can bind a new school board within their own school district, because that's a continuation of the previous
But
board.
what's the distinction? I mean, what's the difference?
This distinction is Easton is a separate entity, a separate corporation, if you will, as a new school district that was never part of the deal, never part of the agreement. In my opinion, by the way, it totally is a poison pill. The successor language was put into the agreement to try to force Easton to be part of that agreement and invent the reorganization pass. At the time, they wouldn't have known whether it was going to pass or not, but it was pending, so they knew that there was certainly a likelihood that it might pass, and therefore they did put in the poison pill. It's a $500,000 deal per year. That's what it costs.
You know, these arguments you're making now were not made in your briefs. Your brief argument was, as a matter of law, the district court was wrong. When you filed your resistance to motion for summary judgment, you had 5 or 6 different arguments, clean hands, and I can't forget what they all were, but you didn't make any of these on appeal.
Well, I agree with the district court's decision, so I've focused in on the
You
district
can't
court
raise
decision.
alternative grounds to affirm unless you argue them on appeal. That's one of our error preservation rules.
I'm not raising alternative grounds. Everything I just said is all included in my brief somewhere.
The poison pill doesn't go, I mean, I could see
I never used that poison pill word, but I got the 500,000 in there.
see the language going, was it the intent of the parties to make the agreement binding on a successor corporation, or was it not? That might be a fact issue, but you never raised it on appeal. In fact, you didn't even raise that down below.
I didn't raise that intent issue, no. But I'm not the one appealing. I want to point out to you that even if you look at the whole grade sharing statute, 282.10, the language in there says that whole grade sharing agreement signed by the board of the districts involved. Easton was never involved. Easton never signed anything. Easton never agreed to anything. And it clearly says signed by the board of the districts involved. The statute doesn't contemplate the situation that took place here where there's a third party that those parties are binding. And we would argue that that interferes with that legislative function, just as the district court found.
So is it your position basically there would be no way to write a whole grade sharing agreement that would be binding in the event of a school reorganization? Cannot be written.
It can be written to bind the two parties.
But not
a third party.
But not if they reorganize and merge.
Right.
I mean, don't you see there's some maybe public policy, we're talking about public policy danger there, because the whole grade sharing agreement admittedly requires a lot of advanced investment and advanced planning, right?
Correct, but the public policy argument would be the other way around, the way I look at it, because what could happen is two boards could get together from two school districts and write something that's totally atrocious that binds the third district, and then turn around and say, well, you're bound to it because now you're going to be part of our group. We got enough votes.
Right, but we talked about that with Mr. Bracken. I mean, if you made the record and you showed that, then that might be, if you showed sort of a bad faith or an unconscionable agreement or something like that, there are defenses under contract law. But to say you simply can't write that kind of agreement seems to me to create a real deterrent to establishing these whole grade sharing agreements, because you can always have a merger. Could happen at any time, right?
You can always have a merger, but it's extremely unusual to have a merger where there's a sharing agreement that binds a third party. I've never seen it before, and I've been doing mergers for 20 years.
But if you look on the,
There's no case law either.
if you look on the Department of Education website, they have forms for these, and one of the provisions in some of these forms say this agreement is void upon a merger of a school district. So wouldn't that indicate to you that they're not void? I mean, at least from the Department of Education standpoint?
Well, maybe from their standpoint, but that's not what happens here because East Central and Northeast, especially Northeast, don't want to make it void if there's a reorganization. Because if it was, then we wouldn't get all those kids back, and the reorganization would be as the public intended when they voted, i.e. all the kids are going to the new Easton School District, not just those that are left over from Northeast. I mean, 712 is a big deal, and in this 3-year sharing agreement, all the 712 kids go to Northeast. So it's not just a temporary deal. Once the kids get started going there, to me it's pretty obvious. A lot of them are going to want to keep going to Northeast, and they're going to open roll. We can just open roll, and we lose all those kids. And in fact, by the way, that's already a problem.
What's the legal significance of the successor language added to the whole sharing agreement on its renewal? Does that make any difference if by law, upon the merger, the new merged district takes on the contractual obligations of the earlier parties anyway?
Well, except our position would be that by adding the word successor in there, what they're trying to do is force Easton into the agreement, and Easton was never part of the agreement. It was illegal to start with.
Doesn't it inherit the assets and liabilities of the merged districts anyway?
Right, but we would argue that was not an asset. But you could argue they inherit the assets and liabilities, but like I said, we'd argue it's not an asset. Although, by the way, if it is an asset, if it really is truly an asset to Easton, then it's also an asset to Northeast. And if it's an asset, then I think under 275.29, then the Ruthven doesn't overrule, or isn't overruled totally by that statutory change. The statutory change of 275.1 says that it's affected schools that are named in the petition. So if you're named in a petition, well, okay, then you got rights because you're affected. But 279.29 still says affected schools by the reorganization. And those schools would be the ones that have some assets that are in play, liabilities in play, and in that case, then Northeast would be an affected school because like I said before, it's $500,000 a year, so they have a big interest, just like Emmitsburg did in that other case. They had a big interest, even though they're not named in the petition. So either way you look at it, I think this thing favors Easton.
Well, again, I guess I'm disagreeing, but, my question is, wouldn't that be all part and parcel of the decision-making process of each of these respective community school districts? You know that if it says you're going to divide assets and liabilities, once you're putting this out for a public vote, it's almost an affirmative duty on the boards to say, and by the way, we do have these whole grade sharing agreements. I think there was a separate agreement that talked about facilities improvement. I mean, this should all be part and parcel of the sale of this whole consolidation and reorganization to the public who's voting on this, and realizing that, oh, by the way, if we do continue with this reorganization, it's still going to be subject to this whole grade sharing agreement that we have. Isn't that all part and parcel of any type of business and negotiation? And
Excuse me.
just like you would if you were buying a office building, and by the way, it's all subject to these leases that are continuing to exist. It's very simply and similar to that, I would see.
I agree, in the best of all worlds, you'd want everything out there, everything in front. But you got to realize that this is not the best of all worlds. It's not even close. You got boards that are fighting with each other, parties that don't get along. And this reorganization got litigated for 2 years because East Central took it to court. That's the only reason that the sharing agreement got completed so far in advance of the reorganization passing, because it was fought out for 2 years. It came to this court previously, and you ruled that the agreement was in good order, and therefore they could go forward, and they did in the past. But was it really clean when it comes to looking at all these other issues? Of course not. It's just not going to work that way because of the politics involved. By the way, you get your TVs back tonight. Anyway, I also want to mention that there's a lot of rights that Easton loses as a result of this agreement. They lose the right to where their students are going to be taught, which teachers, which subjects, the graduation requirements, the educational program, the curriculum, and all those things, the rights are covered by Chapter 279.13, 279.11, and 280.3, etc. This is a major deal and a major consequence to the school district that I think would do a lot of harm to other school districts in the future if you would rule that Easton has to accept this sharing agreement, that they're stuck with it, because Easton's rights, they're all trashed, basically. Yeah, maybe for only 3 years, but what do you got left at the end of the 3 years? You won't have anything hardly left. All the kids will open roll, because once they start high school somewhere, they're not going to drop out and just quit. And I think the successor language, which you picked up on already, but I think the successor language is very clear. It's the only 2 words they added, and successor. It's very clear what their intent was. Their intent was to drag Easton into this thing and make sure we can't get out. And whether we could have gotten out with if it didn't say and successor or not, I don't know, because we don't have to deal with that situation since it's in there. But it's pretty clear to me what their intent was. And if you look down to their timelines, it makes it even more clear, because the sharing agreement doesn't get agreed to until after that merger was accepted.
Doesn't that also lead a certain degree of certainty?
Pardon me?
By adding that language, doesn't that also incorporate a certain degree of certainty in the contract then as well?
Well, sure, it'd make a difference in that way, but by the same token, we'd argue it's illegal to start with, so why would we do that? Thank you.
Thank you as well, Counsel. Mr. Bracken, you may present your rebuttal.
Thank you. I just want to take the quick opportunity to offer a couple of answers to the questions that were raised. I think the point right on the head there at the end about the successor language added to the renewal of that agreement, it was a clarification. And no, our position is it didn't really change the legal impact of that decision. Whether the contract was amended or whether it is just a continuing on in its short life cycle, the same effect would have been happened in the event of a reorganization. The merger would, I like the idea of the lease too, the merger takes the leases and all the other obligations that come with it, whether they're leases or whether they're Coke products being sold at the football field or what have you. Or what commonly we might get into in these days is we might have contracts worth hundreds of thousands of dollars when we're talking about curriculum or perhaps technology and that sort of thing. And those contracts would be just as binding on the successor corporation as it was on the predecessor corporations. Yeah, the idea of adding those two words to the renewal merely were for clarification and didn't really have any legal impact at all. But was it the kind of reassurance that the folks at Northeast needed to make sure they still had faith and confidence in that agreement? And the answer is yes.
Well, let me come back at you again. I'm sitting here listening to the argument flow, and by contract, two parties ought not be able to oust the power of a third party to engage in its fundamental governmental functions. The fundamental governmental function of the new party, providing education to the students, you're basically saying they cannot, this new entity cannot make basic decision-making with respect to the manner in which education is delivered because earlier parties have entered into a contract. Now, does that strike you as right?
Absolutely. But when the contract is authorized under the code, and that's exactly what 282.10 authorizes, these kinds of whole grade sharing agreements.
It is
And I have to go back to my original point, too. When these contracts were formed, there was no third party. There was the possibility of a third party. It could just as easily have been a different kind of third party. They could have Preston could have reorganized with Northeast instead of East Central. East Central could have gone north.
And in a technology agreement, like you alluded to, that could also be something that a burdensome technology agreement could also be something that might be viewed as impeding a merger or something like that.
Possibly.
That's the nature of agreements and
Sure.
mergers, right?
You know what, exactly. You get what you take, and you go into it with your eyes open. In this case, the voters have to go into it with their eyes open. And by the way, the voters went into it knowing the successor was bound. Is that a bad thing, making sure the voters know that? And when I'm talking about technology in the school world, we're talking about, Apple iPads in kids' hands. And that's what I'm talking about. So it does go to that educational function just as much as a whole grade sharing agreement does. So for all the reasons, unless there's any other questions.
Yes, I'm going to follow up with one more question. So if there's a pending vote on a consolidation, the two school districts' board of directors opposes, they can enter into any contracts of any kind on any subject that will be binding then on the future entity if the voters vote yes.
As long as it's authorized by law, and as long as they don't, bump into
Don't have
the-
unclean hands.
Exactly. I think that's fair to say. So the same contract provisions that would apply with any contracting party. Yes. Once again, thank you very much.
Thank you as well, Mr. Bracken. The case is now submitted, and we'll next hear the arguments in State versus Seats.